Hello, Colorado Realtors. I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. So I don't know about you guys, but when we get around the holidays here, I start thinking a lot about good deeds. I think a little bit about some bad deeds. And I also think an awful lot about Colorado property deeds. Haha. See what I did there? So it's particularly important to be thinking and talking about Colorado property deeds at this holiday season because effective after January 1st, 2019, as all of you good realtors know, we're going to be having some contract changes. And there's a whole host of contract changes that are coming in the new form contract. If you haven't already accessed that contract, downloaded it, and had a look at the red line with all of the changes that are coming, I'd really encourage you to spend a little bit of time hanging out underneath the mistletoe with your new red line of the Colorado contract to buy and sell real estate, or not. But anyhow, one of the big changes is coming in paragraph 13 of the contract, and for many years, many years, in fact, everybody probably was trained in pre-licensing. Under the current contract, it says at closing, the seller to deliver to buyer a good and sufficient blank warranty deed or blank deed. And what do you write in there? You write in general warranty deed. In residential transactions, I'd say it's 95% of the contracts, maybe 100% or 99% of the contracts anyhow, are conveyed with a general warranty deed. Well, the change that's coming in 2019 is that the form is now going to, paragraph 13 of the contract to buy and sell, is now going to default to a special warranty deed. And that's a pretty big shift from the way things have been done. Underneath that paragraph, as a subsection of that paragraph, there will now be check boxes where the parties can negotiate and check either a general warranty, bargain and sale, quitclaim, personal representative deed, or a blank other type of deed, which might be a beneficiary deed or some other form of deed, trustee's deed that might be put in there. And so, but if nothing is checked, if no additional steps are taken, then what will be conveyed at closing is a special warranty deed. And that's very different, as I mentioned, for residential real estate transactions. So I wanted to take, because I think that this is going to create a little bit more negotiation potentially around the form of deed that's ultimately delivered in the contract. And I wanted to take a Legal Bites session to talk quickly about what we've got in terms of deed forms in the state of Colorado. And we really only have 4 deed forms that are what I'll call statutory deed forms that are recognized in the state. The first one is general warranty deed. And I want to just explain essentially what that is. And a general warranty deed, and that's what you all have probably been using for a number of years, both on the buy and sell side when you write a contract. General warranty deed, what that means essentially is that the seller, when they give that deed to a buyer at closing in exchange for the consideration, when they are the grantor to the grantee in that case, what they're giving is, in addition to the property and title to the property, they are giving warranties that say, listen, I'm going to defend your rights to this property, your title to this property against any encumbrances or deficiencies to title, not just anything that I may have done to the property during my period of ownership of the property, but anything that may have ever been done to the property at any given time in history. And so that's pretty heavy implications for a seller who's handing out a general warranty deed and is making certain warranties and representations related to encumbrances, the adequacy of title, and so forth. Now obviously there are exceptions to that deed that should be listed on the deed itself, and those would be exceptions to those sellers' warranties. But it's still an awfully large commitment that a seller is making in giving a general warranty deed to a buyer. And so what's going to happen now in the absence of additional negotiation on the contract after January 1st, what will be delivered is a special warranty deed. Probably in most cases more appropriate for a seller to be making warranties with regard, in a special warranty deed, warranties with regard to only things that the seller may have done during, or that may have occurred during the seller's ownership of the property. In other words, it's not going back to the beginnings of the dirt or the origins of that property. A special warranty deed are just warranties that a seller is giving, saying, hey, I will I will defend you against any encumbrances or claims that may have arisen during my period of ownership of the property, but not forever, to the beginnings of time, should I be on the hook for that. And that's the concept of a special warranty deed. And again, that's going to now be the default form of deed that's given in the contract to buy and sell, assuming the parties don't take some additional action to negotiate another form of deeds. And then the last two forms of statutory deeds that we acknowledge in the state, I'll go out of order here and address the quitclaim deed because that's the easiest. A quitclaim deed is, as most of you know, that's just basically the seller saying, hey, I'm going to give you what I've got at the current period of time. Whatever I currently have, I'm giving to you. I'm making no additional warranties, not giving you any other representations, no promises to defend the adequacy or sufficiency of title. I'm giving you just what I have, nothing more. Quitclaim deeds are very common in maybe an intra-family deal, or if you're trying to get somebody off or on title or off title. Maybe you're a family that's created a family trust and you want to move your home, your residence that you already hold title to. You would quitclaim that into the name of trust just to merely move title. It can also be used in an traditional arm's length transaction for sale. That's just based on the negotiation of the parties. So if that works for the buyer and the seller in the transaction, they can certainly contract to give a quitclaim in a more traditional setting as well. But no reps or warranties. It's not a warranty deed in any sense that a seller is giving to a buyer. It's the cleanest form of deed to give. And then we've got the bargain and sale deed, which is, simplifying here, but basically it's a quitclaim deed where a seller is saying, hey, not only am I giving you only what I've got now, I'm just giving it to you with no additional warranties, but I'm also going to give you any after acquired title. So in the event that I have some property right is eventually created in me with relation to this title, then that also is coming with what I'm giving you today. So it's not just what I have today, here you go as a quitclaim deed, it's what I have today, but also anything that I might in some manner acquire at some later point in time, I'm also going to give that to you as well. And that's a bargain and sale deed. And that's what we commonly would refer to as a personal representative's deed or a trustee's deed or a conservator's deed or a guardian's deed maybe. There's other names for it, but those are, in most cases, those deeds where a third-party fiduciary or a government official, a judge, or somebody is signing that deed, those are generally going to be bargain and sale deeds. So much less common, but those are the only four forms of statutory deeds that we have in the state. And so now that I think there's going to be a little bit more discussion around, in paragraph 13, around what parties are going to be conveying to each other, I wanted to give you guys a quick update. As a Christmas present, kind of under the Legal Bites Christmas tree, I've also written up kind of a summary of what I've discussed here. It's just a little blog post, and somewhere down below the video, you ought to be able to click on a link, and that'll take you to the CAR website and a blog post with a recap of and maybe a little bit more detailed information on what I've described here in this particular version of Legal Bites. So I will also say, and I'm not going to get into the weeds on this, that there is probably going to be some legislation that comes early next year in the legislative session, just after January turns the corner. And CAR has been working with some other stakeholders on that legislation. And that might change the statutory form deeds, create some statutory exceptions, and potentially change paragraph 13 yet again very early next year. Now, I know everybody understands our forms moratorium where our contracts only change every 3 years. They don't change. Once they're changed, they're locked down. But one of the exceptions to that moratorium mandate is if there's a legislative change that requires a modification to the contract. So stay tuned just after the next year, at some point maybe end of first quarter, beginning of second quarter, we might, assuming the legislature adopts a proposed statute that's floating around, we might see kind of an emergency contract change where paragraph 13 to the contract and a couple of other areas might require a modification. And you'll get lots of notice and there'll be lots of education. I'll make sure I do something when that comes around, if it comes around, based on what the legislature ultimately does. So I'm not going to get into that, but into any more details on that, but it certainly could happen after the new year. All right, we're adding this new slide every session to our education events and conferences. This is stuff that CAR is going to be doing next year. I'm not going to spend a lot of time on it, but it's our Economic Summit and Realtor Day at the Capitol, the Spring Summit and the Fall Forum. You can click on that link or go to the link below that's seen here and get to the website with additional information. We love to see you at these events. We always try and put on some great content and education in addition to the business meetings that we have. And so do be mindful of that. As always, if you have problems or questions about deeds or other issues related to contracts or some of the new contract changes, the Car Legal Hotline is available from 9 to 12 and 1 to 4, Monday through Friday. Do check in on the holiday hours because we're having a little bit more limited holiday access just based on our office closures during the holiday period. But after that new year gets going, then make sure you reach out and check in with us on the hotline. Thank you for joining me for another edition of Legal Bites. I hope everybody's enjoying their holiday season. Merry Christmas, Happy Hanukkah, and all the other good stuff. And we will see you soon. Thank you.